Good evening. This is not just another courtroom headline. This is a political earthquake. Moments after Melania Trump delivered what insiders are calling a bombshell testimony, the atmosphere inside the courthouse shifted from tense to explosive. Witnesses describe chaos, doors closing, phones seized, and then US Marshals moving in. What did she say that triggered such an immediate and dramatic response? Why were assets reportedly seized without warning? And who exactly is feeling the impact tonight? This is not rumor. This is not speculation. This is a developing story shaking the highest levels of power. Stay with us, because what happened after that testimony may change everything. Melania's appearance before the Supreme Court instantly transformed an already high-stakes legal battle into a moment of national fixation. From the second she stepped into the chamber, the atmosphere shifted. Observers noted the stillness, the kind that settles in when history feels close enough to touch. Dressed with calculated restraint and composed expression, she carried herself with a calm that contrasted sharply with the political storm surrounding her testimony. Cameras were barred from the courtroom, yet every detail leaked outward within minutes, carried by reporters, aides, and stunned spectators who struggled to describe what they had just witnessed. According to those present, her voice was steady, deliberate, and unwavering. She did not rush her words. She did not appear rattled by the weight of the questions. Instead, she delivered answers that were described as precise and at times unexpectedly direct. Legal analysts following the proceedings say the tone of her statements marked a sharp departure from previous public appearances. This was not a ceremonial address or a carefully choreographed interview. This was sworn testimony under the highest judicial authority in the country. Each word carried consequence. Sources inside the chamber claim that the most explosive moment came when questioning turned toward internal communications and decision-making processes behind closed doors. It was here, insiders say, that the temperature in the room seemed to rise. Several justices reportedly leaned forward. Attorneys shifted in their seats. What she revealed, or what she implied, sparked an immediate ripple of whispered exchanges among legal teams. Though official transcripts would later provide clarity, those initial minutes were defined by tension and uncertainty. Observers described a visible reaction among court officials when certain statements were entered into record. There were pauses longer than usual, requests for clarification, a noticeable tightening of procedural language. Political figures outside the courthouse were simultaneously reacting in real time, issuing statements within minutes, some expressing shock, others questioning the broader implications. Social media platforms surged with speculation, fragments of information, spreading faster than confirmation could keep pace. Legal experts analysing early reports suggested that her testimony could carry implications beyond the immediate case. Some pointed to potential conflicts between public narratives and sworn statements. Others focused on the legal strategy behind her decision to testify in such a high-profile setting. Was this a calculated move to establish credibility, a defensive measure to preempt further scrutiny, or a pivotal turning point in a larger, unfolding legal confrontation? Inside the courtroom, the mood reportedly oscillated between procedural discipline and barely contained intensity. At one point, attorneys were said to have requested a brief recess, though officials declined to comment on the reasoning. The break, brief as it was, only fueled speculation outside. News organizations interrupted regular programming. Analysts scrambled to interpret partial accounts. The phrase bombshell testimony began trending within the hour. What made the testimony particularly striking was not only the content, but the context. Rarely does a former First Lady find herself at the center of such a consequential judicial moment. The symbolic weight alone ensured global attention. International outlets picked up the story almost immediately, framing it as a dramatic chapter in an already turbulent political era. Commentators debated whether the testimony would reinforce existing divisions or shift the narrative entirely. By the time proceedings resumed, the sense that something significant had occurred was undeniable. Even without full public access to every exchange, the reaction spoke volumes. Lawmakers were reportedly in urgent consultation. Advisors convened behind closed doors. Statements were drafted, revised, and sometimes withdrawn within hours. The ripple effects were no longer confined to the courtroom walls, spreading outward into the broader political landscape, where alliances, strategies, and reputations hung in delicate balance amid intensifying scrutiny and mounting questions across Washington. The tension inside the courtroom did not build gradually, it detonated. What had begun as a controlled formal proceeding suddenly unraveled into a scene few expected to witness within the nation's highest judicial chamber. Observers described a palpable shift in the air, as if the gravity of the testimony triggered an immediate chain reaction. Attorneys who moments earlier appeared composed were seen urgently conferring in hushed, rapid exchanges. Court staff moved with unusual speed. Even seasoned reporters struggled to interpret what they were seeing in real time. It started with raised voices, moxes, not shouting, but sharp, forceful objections cutting through the structured rhythm of questioning. Legal teams began interrupting more frequently. Requests to strike statements from the record came in quick succession. One exchange reportedly grew so heated that a justice had to firmly call for order. The command echoed across the chamber, underscoring that procedural discipline was beginning to fray under pressure. Witnesses noted visible reactions across the room. Some officials exchanged stunned glances. Others stared down at documents, flipping pages as if searching for context that could contain the moment. The gallery, though instructed to remain silent, seemed collectively frozen. The tension was not theatrical, it felt raw and unscripted. This was not routine legal friction. Something had disrupted the balance. At one point, multiple attorneys stood simultaneously, attempting to speak over one another before being directed to sit. The interruption forced a temporary pause in questioning. Court officers shifted position, subtly but noticeably, as if anticipating further escalation. Security presence, while always standard in such proceedings, suddenly felt more pronounced. The stillness between exchanges became heavier than the arguments themselves. Outside the courthouse, the sense of disorder quickly mirrored what was unfolding within. News correspondents rushed to update their networks, some abandoning prepared segments mid-sentence as new details filtered out. Political commentators began speculating about procedural violations, potential contempt issues, and the broader consequences of what appeared to be an unprecedented confrontation at the highest judicial level. Inside, the presiding authority worked to restore order, reiterating the expectations of decorum. But the rhythm of the session had been permanently altered. Each subsequent question carried sharper edges. Each response was scrutinized not just for content, but for tone and implication. The atmosphere felt charged, as if any statement might ignite another surge of objections. Legal aides scribbled notes with urgency. Documents were passed back and forth more frequently than before. Several accounts suggest that the chaos was not merely verbal. There were moments of confusion regarding procedural steps, overlapping motions, clarifications requested and contested, timing disputes that compounded the strain. The structure that normally defines Supreme Court proceedings seemed momentarily stretched under the weight of unfolding revelations. Observers described it as watching a carefully engineered system strain against unexpected force. The disruption extended beyond legal maneuvering. The emotional undercurrent was unmistakable. Faces hardened, expressions shifted from measured professionalism to visible strain. Even those accustomed to high-profile litigation admitted later that the intensity felt different, heavier, more volatile. The sense that the stakes had escalated in real time was impossible to ignore. Meanwhile, reports began circulating that external authorities were being notified of developments. Though details remained unclear, the mere suggestion added another layer of urgency to an already unstable situation. The possibility that immediate actions could follow testimony heightened the sense of unpredictability. As questioning resumed, it was no longer a standard examination, but a controlled attempt to navigate turbulence. Interruptions persisted, though more restrained. The chamber never fully regained its earlier composure. What remained was an unmistakable awareness that the proceedings had crossed into extraordinary territory, where every word, objection, and procedural move carried amplified consequence under mounting national scrutiny and intensifying political pressure from every direction. The arrival of US Marshals marked a decisive turning point in an already volatile situation. Their presence was not announced with spectacle, yet it carried unmistakable authority. Within minutes of the most intense exchanges inside the courtroom, reports emerged that federal officers were moving swiftly through secured corridors. Observers described a sudden tightening of perimeter control, with access points restricted and identification checks intensified. What had been a tense judicial proceeding now appeared to be transitioning into an active federal response. Witnesses inside the building noted coordinated movement rather than confusion. Marshals communicated in low, direct tones, their actions measured and procedural. There was no visible rush, yet the urgency was evident in their pace and precision. Certain areas were quietly cleared. Specific individuals were approached and instructed to remain available. The atmosphere shifted from legal confrontation to enforcement readiness. It was no longer just about testimony, it was about immediate containment and control. Outside the courthouse, the sight of federal vehicles positioned strategically near entrances fueled speculation. Media crews pivoted their cameras toward the new development. Commentators struggled to explain whether the response had been pre-planned or triggered by unfolding the lack of official statements only deepened the sense of gravity surrounding the operation. The Marshals' role is typically associated with security and the enforcement of federal court orders, and their visible mobilization suggested that events had surpassed routine judicial management. Sources indicated that certain materials were being secured under formal authority. Boxes, sealed envelopes, and electronic devices were reportedly catalogued with methodical care. Each action appeared grounded in procedure, yet the timing amplified its impact. The connection between the testimony and the enforcement activities seemed immediate, even if official confirmation remained absent. Observers described a noticeable stillness among those present as they processed the implications of federal officers executing duties in direct proximity to Supreme Court proceedings. Legal analysts began weighing in within minutes, outlining the potential reasons for such a rapid response. Some suggested the possibility of protective measures tied to sensitive disclosures. Others speculated about compliance enforcement related to court directives. The exact legal basis remained undisclosed, but the optics were unmistakable. Federal authority had moved from passive security presence to active operational engagement. Inside secured areas, coordination appeared seamless. Marshals conferred briefly with court officials before proceeding with clearly defined tasks. There was no visible confrontation, no dramatic physical altercation, only structured execution of duty. Yet the symbolism resonated beyond the immediate environment. The image of federal law enforcement stepping in so swiftly after explosive testimony sent ripples across political and legal circles nationwide. Lawmakers reportedly began contacting advisors as soon as confirmation of the Marshals' activity spread. Political strategists shifted messaging in real time. News alerts labeled the development as unprecedented, even as experts cautioned against premature conclusions. The controlled demeanor of the officers contrasted sharply with the intensity of the courtroom moments that had preceded their movement, reinforcing the sense that protocol was guiding each step. Security around the courthouse perimeter tightened further as the operation continued. Entry points were monitored with increased scrutiny. Individuals attempting to approach restricted zones were redirected without explanation. The lack of public detail did little to temper speculation. Instead, it magnified the perception that consequential actions were unfolding beyond public view. Throughout the operation, the Marshals maintained a disciplined presence, avoiding commentary and deferring questions to official channels. Their silence became part of the narrative. In high-profile federal situations, enforcement speaks through action rather than statement, and each measured movement carried weight. The response suggested preparedness, as though contingencies had been established well before the day's proceedings reached their most volatile moments. As materials were secured and personnel movements coordinated, the broader impact became clear. The testimony had not only stirred legal debate, but triggered tangible federal enforcement activity. The transformation from courtroom intensity to operation execution underscored the seriousness of the moment, embedding the image of US Marshals in motion into the unfolding national conversation and reshaping perceptions of the day's events across political and legal landscapes. The sudden seizure of documents and assets unfolded with striking precision, adding another dramatic layer to an already explosive day. What began as heightened courtroom tension quickly translated into formal action, as authorized officials moved to secure materials believed to be central to the unfolding legal developments. Witnesses described an atmosphere of controlled urgency, where every movement appeared deliberate and backed by procedural authority. According to reports from inside the building, federal officers presented official documentation before initiating the collection process. The actions were not chaotic or improvised. They followed a structured sequence. Specific files were identified, catalogued, and placed into secured containers. Electronic devices were carefully handled, labeled, and documented. Each step suggested adherence to strict evidentiary protocols, reinforcing the seriousness of the operation. The scope of the seizure quickly became a focal point of speculation. Observers noted that it was not limited to a single stack of paperwork or a single device. Multiple categories of materials were reportedly involved, ranging from physical documents to digital storage, equipment, the presence of technical specialists hinted at concerns surrounding data preservation and forensic analysis. Hard drives, laptops, and encrypted communication tools were treated with particular caution, emphasizing the potential sensitivity of the information involved. Legal analysts watching developments unfold suggested that such comprehensive action typically signals concern over the integrity or accessibility of key evidence. When authorities move to seize materials so swiftly, it often reflects a determination that delay could compromise investigative or judicial objectives. The timing, immediately following intense testimony, intensified public interest and speculation about what those materials might contain. Outside the courthouse, news of the seizures spread rapidly. Media outlets interrupted programming to report that assets were being taken into federal custody. Political figures issued statements expressing either support for strict enforcement of legal procedures or concern over what they characterized as aggressive measures. The narrative expanded beyond legal circles, drawing reactions from commentators across the ideological spectrum. Inside, the process remained methodical. Officials reportedly cross-referenced items against court directives before removal. Chain of custody procedures were meticulously followed to ensure admissibility in any future proceedings. Boxes were sealed in full view of authorized witnesses, reinforcing transparency within the bounds of legal confidentiality. Despite the dramatic optics, the operation appeared rooted in established enforcement frameworks. There were also reports that certain financial records were among the seized materials. Though details remained undisclosed, the possibility of asset-related documentation broadened the perceived implications. Financial analysts speculated about potential investigations tied to disclosures made during testimony. The phrase "seize everything" gained traction in headlines, reflecting both the breadth of action and the intensity of public reaction. Security personnel maintained a controlled perimeter as materials were transported. Vehicles designated for secure transfer were positioned strategically, minimizing exposure while ensuring swift movement. The coordination suggested pre-authorization and logistical planning rather than spontaneous decision-making. Each container loaded into transport vehicles symbolized another layer of consequence stemming from the day's revelations. Observers inside the building described a noticeable shift in demeanor among the anbeening. Most of those present, legal representatives appeared focused and reserved, aware that the removal of documents could significantly influence the trajectory of ongoing proceedings. Conversations were subdued, often confined to brief exchanges behind closed doors. The tangible removal of records transformed abstract legal debate into concrete action. Speculation continued to mount regarding the long-term implications of the seizure. Would the materials substantiate claims raised during testimony? Could they introduce new lines of inquiry? Or might they complicate existing legal strategies? Without official disclosure, the answers remained uncertain. But the scale and speed of the action ensured that the development would dominate headlines and analysis cycles for days to come. As the final secured containers were moved from the premises, the visual impact lingered. The image of federal authorities systematically removing documents and assets underscored the gravity of the moment, reinforcing the perception that the events triggered by testimony had escalated into a significant and potentially far-reaching legal confrontation under intense national scrutiny. The political shockwaves were immediate and far-reaching, rippling outward from the courthouse into every corner of Washington. Within minutes of reports detailing explosive testimony, courtroom chaos, and federal seizures, lawmakers began reacting publicly and privately. Phones lit up across Capitol Hill. Advisors were summoned into urgent strategy sessions. Statements were drafted, revised, and in some cases withdrawn as new fragments of information continued to surface. Members of Congress from both parties moved quickly to frame the narrative. Some described the developments as proof that no individual stands above the law, emphasizing the importance of judicial independence and enforcement authority. Others characterized the events as alarming, raising concerns about due process and the optics of federal intervention following high-profile testimony. The divide reflected the broader polarization that has defined recent political discourse, and this moment intensified those existing fault lines. Party leadership convened behind closed doors, reportedly assessing not only the legal implications but also the political consequences. Election strategists monitored public reaction in real time, analyzing social media trends and early polling indicators. The phrase associated with the day's events surged across digital platforms, amplifying the sense that Washington had entered another chapter of heightened instability. Cable news panels filled with former prosecutors, constitutional scholars, and campaign consultants debating what it all meant for the balance of power. Inside the executive branch, officials were said to be reviewing the situation carefully, cautious about public commentary while legal processes were ongoing. The separation between political leadership and judicial proceedings became a focal point of discussion. Any statement carried potential risk, either appearing to interfere or seeming detached from events that had captured national attention. The silence from certain offices was interpreted by some as strategic restraint, by others as calculated avoidance. International observers also weighed in, viewing the developments as a test of institutional resilience. Diplomatic analysts suggested that the optics of federal marshals executing seizures in proximity to Supreme Court proceedings would inevitably draw global scrutiny. Allies and critics alike examined the episode through the lens of democratic stability, assessing how American institutions respond under pressure. Meanwhile, political advocacy groups mobilized quickly. Fundraising appeals referencing the day's dramatic events began circulating within hours. Activist organizations issued calls for investigations, oversight hearings, or public transparency depending on their alignment. The rapid mobilization underscored how deeply intertwined legal proceedings and political strategy have become in the modern media environment. Veteran lawmakers commented that even in a city accustomed to controversy, the sequence of testimony, chaos, and enforcement action felt extraordinary. Comparisons were drawn to previous historical flashpoints, though analysts cautioned against premature parallels. The uniqueness of the situation lay in its convergence of high-profile testimony and immediate operational consequences, a combination that intensified both legal and political stakes simultaneously. Public opinion appeared sharply divided. Supporters of decisive legal enforcement viewed the developments as necessary accountability. Critics warned of potential overreach. The narrative evolved hour by hour, shaped by emerging details and partisan interpretation. Town halls, press briefings, and impromptu interviews reflected a city in reactive mode, attempting to keep pace with events that refused to settle into a clear pattern. Behind the scenes, legislative aides began reviewing potential implications for pending bills and committee priorities. Oversight committees discussed whether hearings might be warranted. Policy agendas were temporarily overshadowed as attention narrowed to the unfolding controversy. The shockwaves were not limited to rhetoric. They influenced scheduling, messaging strategies, and internal calculations about political risk. As the news cycle intensified, one reality became clear. The events had transcended the courtroom. They had entered the bloodstream of national politics, reshaping conversations, recalibrating alliances, and reinforcing the fragile equilibrium between law and power that defines governance in Washington under relentless public scrutiny. What this means moving forward is a question now echoing across legal circles, political institutions, and the broader public sphere. The events that unfolded have shifted the trajectory of more than a single case. They have introduced new variables into an already complex landscape. Legal experts suggest that the immediate consequences will likely involve intensive review of the seized materials, detailed analysis of sworn testimony, and careful evaluation of procedural steps taken during the response. Each development from this point carries amplified significance. In the judicial arena, the next phase could involve motions challenging or defending the scope of enforcement actions. Attorneys may seek to limit admissibility of certain materials, argue procedural overreach, or request protective orders to manage public disclosure. The courts, in turn, will be tasked with balancing transparency against confidentiality, ensuring due process while addressing the seriousness implied by rapid federal intervention. The pace of filings may accelerate, reflecting the heightened stakes introduced by recent events. For investigators, the path forward likely centers on forensic examination. Digital devices secured during the operation could undergo extensive analysis, with specialists extracting communications, metadata, and financial records. The integrity of evidence will be scrutinized carefully, with chain of custody documentation playing a critical role in any future proceedings. Each verified detail has the potential to clarify, complicate, or redefine the narrative that began in testimony. Politically, forward movement involves strategic recalibration. Elected officials must decide how prominently to engage with the controversy. Some may double down on calls for accountability, framing developments as validation of institutional strength. Others may push for oversight hearings or public disclosures to examine the circumstances surrounding enforcement decisions. The coming weeks could see legislative initiatives aimed at reinforcing or questioning procedural safeguards. Public perception will also shape what happens next. Opinion polls, media framing, and grassroots activism can influence the tone of national conversation. In a hyper-connected environment, narratives evolve quickly, and the interpretation of events often proves as consequential as the events themselves. Advocacy groups are likely to sustain pressure campaigns aligned with their perspectives, ensuring that the issue remains in headlines and policy debates. The legal team at the center of the controversy faces a complex road ahead. Crafting responses that address both judicial scrutiny and public opinion requires precision. Statements must be measured, filings carefully worded, and strategy coordinated across multiple fronts. Every communication will be passed for implication. Silence may be interpreted as caution or vulnerability. Assertiveness could be framed as confidence or defiance. Institutionally, the situation tests procedural resilience. The judiciary's handling of subsequent motions, the enforcement community's documentation of actions taken, and the political branch's response will collectively influence public trust. Observers will watch for adherence to established norms, transparency in explanation, and restraint in rhetoric. Deviations from protocol, even minor ones, could fuel further controversy. The broader legal precedent is another dimension moving forward. If enforcement actions tied directly to courtroom testimony become central to the case's evolution, scholars may debate implications for witness participation in high-profile matters. Questions about privilege, disclosure obligations, and rapid operational response could shape future judicial guidelines. Academic and policy forums are likely to dissect the sequence of events for years. Media organizations will continue investigative reporting, seeking confirmation of details that remain unclear. Leaks, official statements, and court filings will contribute to a developing mosaic of information. Each new piece has the potential to shift emphasis, alter interpretations, or introduce additional complexity. As the immediate intensity transitions into sustained legal and political maneuvering, the focus turns to how institutions navigate the aftermath. The intersection of sworn testimony, federal enforcement, and political reaction ensures that the path ahead will remain closely watched, with outcomes dependent on procedural rigor, evidentiary clarity, and strategic decisions made under the weight of unprecedented scrutiny